material also lies in its consistency with and confirmation of the findings of the FFM and the IIM, which serves to underscore and enhance the reliability and weight of the FFM's two comprehensive reports. Mr. Reichler says we place special emphasis on the reports by the FFM and the IIMM, including all of the underlying material on which the reports are based. Although Mr. Reichler says that the Gambia places special emphasis on reports by both the FFM and the IIMM, there is, however, no suggestion that the IIMM material itself could be sufficient to prove genocide. Mr. Reichler furthermore only speaks of emphasis being placed on IIMM reports rather than IIMM witness statements. The IIMM reports do not deal directly with events on the ground in 2016 and 2017, but rather with ancillary matters such as ARSA weapons possession and hate speech and detentions in prison and efforts to prosecute sexual violence. As to the witness statements produced by the IIMM, it's a striking fact that the IIMM has provided some 42 witness statements to the Gambia, and the Gambia has only put 12 of them into evidence in this case. I ask you to pause and think about this. The very institution set up to gather evidence and to produce evidence specifically for use in judicial proceedings and with access to the accounts and identity of all of the hundreds of FFM interviewees, provides just 42 witness statements relevant to the allegations after over 7 years of work. And then the Gambia only files 12 of them. The fact is that unless the FFM reports are given sufficient evidential weight to enable the Gambia to discharge its burden of proof to the requisite high standard, the Gambia simply has no case. Its entire case rests on reports of a fact-finding mission that is 6 or 7 years old and were drafted during a short period of time without proper investigation backing them. In the intervening years, no further evidence has emerged that would be capable of proving a claim of genocide without central reliance on the FFM reports. However, the FFM reports cannot be given evidential weight in relation to the events on the ground in northern Rakhine State in 2016 and 2017. The reasons will be addressed fully in due course. Apart from anything else, the FFM was not a body that was equipped or qualified or had a mandate to produce evidence suitable for use in judicial proceedings, and certainly not to make ultimate findings of fact in accordance with the standard of proof applicable in this case. And it certainly did not apply the standard of proof that the court is required to apply in this case. However, there are also more fundamental reasons why the FFM reports are not capable of enabling the Gambia to discharge its burden of proof to the requisite high standard. The court is a judicial body. It cannot find a state responsible for so grave a matter as genocide, which requires proof to a high standard without proper judicial process. A state defending itself against such a grave accusation must be capable of contradicting and testing the evidence against it. Given the seriousness of the allegations and the fact that proceedings are brought in the common interest of all states parties to the Convention, proceedings of the present kind must be a genuine search for the truth, which requires a proper adversarial process. The Gambia says that the court can rely on the FFM reports, quote, to assist in its own determination of the facts. Yet how is the court assisted by the FFM reports in making its own determination of the facts? The FFM reports simply state bare findings of fact and then cite to unidentified persons as the source of that information, or state conclusions of the FFM itself based on those findings of fact. How can the court make its own determination of facts based on such material? It either accepts the material and rubber stamps it, or it rejects it. But how can the court rubber stamp it? The court must be satisfied of facts to a standard of proof comparable to the beyond reasonable doubt standard of criminal proceedings. How could the court be so satisfied on the basis of bare statements of fact attributed to anonymous persons? This case is an absolutely extraordinary case, where the evidence relied upon by the applicant consists of findings by a third party based on hundreds of anonymous people. Neither of the parties knows who the overwhelming majority of these people are. Not only is the court incapable of making any genuine determination of its own on the basis of these reports, but the respondent also is incapable in any way of challenging or testing the credibility of the evidence. The fact that the FFM reports are accompanied by a sprinkling of other evidence changes nothing. That other evidence collectively is incapable of proving genocide, so that a finding of genocide would still rest on the untestable FFM reports in any event. Furthermore, while that other evidence may be consistent with aspects of the FFM reports, the body of evidence does not corroborate the FFM reports as a whole. That other evidence also has similar deficiencies to the FFM reports. It includes, for instance, reports of other official bodies or NGOs that contain bare statements of fact attributed to anonymous persons. Effectively, the Gambia seeks to shift the burden of proof. It seeks to put Myanmar in a position where Myanmar has the burden of disproving what is stated in the FFM reports. This is, of course, contrary to the established jurisprudence, according to which it is for the applicant to demonstrate the existence of the facts put forward in support of its claims. The court cannot demand of the respondent that it provide explanations of the facts alleged by the applicant. A further objection to reliance on the FFM reports is that Myanmar was under no obligation to cooperate with the FFM, and it did not do so. This means that the FFM reports, in any event, reflect only one side of the story. The Gambia seeks to ridicule this argument. That may be a sign that it has no answer to it. The effect of the Gambia's argument would be to force states to cooperate with bodies that they are under no obligation to cooperate with and have no desire to cooperate with. The FFM has no power to say to Myanmar, you have no duty to cooperate, but if you do not, you may be prejudiced in any future proceedings before the International Court of Justice. Members of the court, would any municipal court that observes the rule of law convict a person of the gravest crime or find against a defendant in the highest stakes civil case on the basis of a report prepared by a third party that simply states facts attributed to anonymous persons? If any municipal court did that, would that be called a legitimate exercise of its fact-finding responsibility? Or would that be called an abnegation of its judicial function? The Gambia may disagree, but the answer must obviously be the latter. Myanmar does not take the extreme position that reports of United Nations bodies can never have evidential weight. Obviously, such reports have been given evidential weight for certain purposes in certain cases. However, there is no precedent for making findings of the core facts in a case where the heightened standard of proof applies on the basis of a report such as this. Contrary to what the Gambia seems to suggest, this is not the court's long-standing practice. In previous cases, the court has exercised due care when relying on reports of United Nations bodies and has rejected claims evidenced by such reports. It has not treated them all as authoritative. The court has affirmed multiple times that the probative value of reports from official or independent bodies depends, among other things, on 1, the source of the item of evidence, for instance, partisan or neutral, the process by which it has been generated, for instance, an anonymous press report, or the product of a careful court or court-like process, and 3, the quality or character of the item, such as statements against interest and agreed or uncontested facts. The FFM reports were certainly not produced by a court or court-like process, and there would have been no such process even if Myanmar had cooperated with it. The sources of evidence in the reports, that is to say, claimed eyewitnesses to events, cannot be considered neutral. Furthermore, the information in the reports is not agreed or uncontested and does not fall in the category of statements against interest. The Gambia suggests that Myanmar's position would make it all but impossible for a state to be held accountable under the Convention. In fact, in some cases, it may well be impossible to hold a state accountable. For instance, because the state is not a party to the Convention, or because the state has made a reservation to Article 9. However, in the case of a state party that has made no such reservation, the way of holding a state accountable is to bring proceedings before this court. Contrary to what the Gambia appears to assume, Myanmar's position would not create a need for a prior determination by a third body, such as the ICTY, before proceedings are brought before this court. If all of the evidence that was before the FFM was before this court, then the court could have considered that evidence itself and made its own findings based on it. This would not involve importing the rules of the International Criminal Court or other rules of criminal procedure into proceedings before this court, and would not necessarily involve the hearing of oral testimony from every witness. This court is always subject to its own statute and rules of court. There may well be challenges in managing such litigation, but not insurmountable challenges. No other court in the world would shy away from hearing the largest, most complex, and most serious cases on the ground that it is hard to do. It's a hypothetical question precisely what evidence would be sufficient to prove genocide in a case before the court. For present purposes, it suffices to confirm that reports of the FFM are insufficient. Mr. President, members of the court, in addition to the disputed issues of fact and disputed issues of evaluation of evidence, there are also certain disputed issues of law in this case. These are most conveniently dealt with as they arise in the course of presentation. I will therefore not identify all of them now, other than to mention three. First, the Gambia appears to suggest that if a genocidal intent is one possible inference to be drawn from the circumstances, it will be proved unless the respondent proffers and presumably proves some other explanation for that conduct. That is incorrect. According to the court's settled jurisprudence, the Gambia bears the burden of proving all legal elements of the claimed breaches of the Convention. In accordance